All right, let's proceed.
Good morning, Your Honors. Richard Briansky on behalf of GMAC Mortgage, LLC, the appellant in this matter. First American acknowledges that GMAC's mortgage was defective. First American acknowledges that the defect identified by GMAC in its mortgage was covered under the terms of its standard policy that it issued. First American acknowledges that it had an obligation to either cure the defect in the mortgage under the terms of its policy or pay the policy amount. The policy gives First American several options. First American specifically selected an option to file an action on behalf of its insured under paragraph 4B of the conditions and stipulations. First American knew, or certainly should have known, that compulsory counterclaims would have resulted from this action. First American in this particular case had even greater knowledge because they were in receipt of a 93A demand letter from the particular mortgagor that they intended to sue. First American nevertheless filed the action, and then when those anticipated compulsory counterclaims, albeit in the Superior Court, but were recognized by Judge Young as essentially counterclaims, but for the fact of the land court's limited jurisdiction.
Can I stop you there, though?
Sure.
I mean, what were the alternatives that the insurer had other than suit?
The insurer, if you look at paragraph 6 of the conditions and stipulations, it provides the insurer several options.
What are the other options?
The other options are to negotiate with the insured.
And that would be solely as to the title issue.
That's correct.
And even though the
They could do both. They can negotiate. They can purchase the debt. They're given several different options. Under
but
that
my question really goes to, would they be obliged to negotiate about claims like the subject of the 93A letter that Mrs. Moore was raising, that I want a refund of what I paid, that I want these other things? Are these all things that the title insurance company would have to negotiate if they undertook one of the options?
Initially, no, Your Honor. This was before Ms. Moore had filed any lawsuits.
No, I understand that. But you're basically saying that one of the reasons why the insurance company should be have to defend against these other claims that were raised by Mrs. Moore in litigation is that it chose to engage in litigation. And what I'm saying is that it had other options. If it chose one of those other options, you might still have liability separately for the 93A related claims. You know, the title insurance company would have perhaps had no obligation to address any of those.
Well, I disagree with that, Your Honor, because had the title insurance company selected one of those other options and cured the defect, which is what they would have had to do unless they tendered us the policy amount, then there wouldn't really have been a 93A claim because we would have had a valid and enforceable mortgage. That was the sole basis of the 93A claim. It was moving to foreclose. I guess technically it could still exist, but it would be significantly less.
But you would still have, for example, if you took that option, you'd still have Mrs. Moore's claim that she should be refunded however much she paid when she actually wasn't obligated to do so. I mean, you'd have that.
Those claims were all raised in response to the initial complaint, so I don't know whether she would have ever raised those claims. It's speculative.
But if she did, you would agree, just to follow up on what Justice Link was saying, you would agree that that would be your responsibility to defend.
That's correct.
Now, how is it a compulsory counterclaim in that the definition of a compulsory counterclaim is if you do not bring it, you lose it. But in this particular case, it couldn't be brought in land court, so it couldn't be lost.
Well, it arose, the court and all the lawyers who have reviewed it have acknowledged that it arose out of the same transaction and occurrence, and it could have been brought if the land court had special jurisdiction. There was certainly a way of asserting it. But it didn't. That's correct.
So why is it compulsory? They had to bring a separate action.
That's correct, Your Honor.
So
it wouldn't necessarily have been a compulsory counterclaim. What I said, Your Honor, is that First American knew at the time that she would have had to bring any compulsory counterclaims when they filed the initial action.
Except the action was brought in a court in which that counterclaim could not be made, so it would have had to be brought separately. So I don't quite see why you say that the initiation of the suit in land court triggered the filing of these claims where they had to be filed in a separate court anyway.
Not only did I say it, Your Honor, but Judge Young found that they were essentially counterclaims, which would have been asserted in the land court but for the fact of the limited jurisdiction.
Okay, but we're obliged to accept what appears to be plainly in error? I mean, he also said that they were consolidated, but they weren't.
That's correct.
So, I mean, well, the questions he asked don't necessarily obligate us to accept those findings, do they?
No.
Okay, so the questions are theoretical.
That's correct.
By nature. Let me step back a little bit. Let's assume you're right. What have we done here? What have we opened the door to? Do we fully understand what we're opening the door to if we accept the principle that the insurer has a duty to defend against all claims in an action where there is, as Judge Young says, an overlap, or where there is a compulsory, or where it's triggered by the title company's initiation of an agreement? Do we understand what this will produce well enough to say that that should be the law?
Well, it is the law now. At least all the appellate courts have recognized that for general liability policies. And the question is here whether the title insurance policy is so materially different, specifically in its obligation to defend under paragraph 4A of the conditions and stipulations, that this court should vary from that rule. And every court, I shouldn't say every court, there are a number of jurisdictions who have considered this very same argument, where title insurers, in particular Chicago title insurance, have made this very same argument. Look at our policy. It's completely different from the general liability policy because we only have to defend against those claims which impact title. We specifically negotiated that. That's part of our claim. And each and every one of these courts, including the Northern District of Ohio, the Illinois District Court, and as well as a federal district court in Texas, have all rejected that conclusion because what those courts have recognized, and I think it's consistent with Massachusetts law, is that the obligation, the in for one, in for all, is not contract interpretation, but rather is applied as a matter of law and public policy.
But I guess that's my point. It's applied as a matter of policy, and said that essentially that any in the general liability contracts, effectively what the law is saying is that regardless of that limitation, as a matter of public policy, we're going to obligate the liability insurers to be in for one, in for all. Should that policy override the contract when we're speaking only about title insurance? I mean, is it the same policy interest? Are we not dealing with a much more defined set of issues which are likely to be litigated in land court, where the range of issues that even may be addressed are going to be much narrower than in a superior court?
I disagree with that, Your Honor. I think some of the policy considerations exist in the same, and I think it's a distinction of form as opposed to substance. When you look at some of the policy rationales by which these courts have arrived at their conclusion in for one and in for all, it deals with the practical implications of having two attorneys dealing with multiple claims in one action. And that manifests itself in this particular case where you have different strategies which may be better for the title insurance company but not so favorable for the insured. This is part of the policy justification. In addition, Judge Woodlock, in his decision in Dash, he quotes from the district court in the bus case, but also identifies a number of other policy considerations which would be equally applicable in the title insurance context. In particular, he says, and he's quoting from bus, that this obligation between covered and uncovered claims, which is how we talk about it when we talk in the general liability context, and the same true is here with the title insurance policy, it may delay the ultimate decision of the insurer while they try to puzzle through which claims are covered and which claims aren't covered, and ultimately are derelict in their duty to defend. In particular, he says, to defend meaningfully, the insurer must defend immediately. To defend immediately, it must defend entirely. It cannot parse the claims, dividing those that are at least potentially covered from those that are not. It's basically obligating the insurer to do exactly what it was contractually obligated to do, which is to defend the insured as to all claims. And I think there's no meaningful distinction between a title insurance and general liability insurance. In fact, once you get away, in fact, when you deal with all these general liability cases, they make the same arguments. Well, those claims aren't covered. Well, what's the difference between those claims aren't covered and the claim that First American is making here? To me, it's exactly the same. And if it's an obligation implied as a matter of law because of those very policy reasons, then that obligation should be applied equally to a policy of title insurance. And I disagree with you, Your Honor, that most of these claims are brought in land court. This Superior Court also has concurrent jurisdiction over these exact same claims. Here, the lawyer for First American made a particular decision to file in land court, but certainly First American attempts to cure various defects in Superior Court as well as land court, and maybe even file an action in federal district court. I don't think it's something that we can interpret so narrowly.
Are you, maybe I misunderstood here. Are you suggesting that First American has an obligation to defend even uncovered claims so long as they're combined with covered claims?
Yes.
Even uncovered claims?
That's right.
Because that's what you say happens with a general liability policy.
That's correct. And it's the same rationale, because those general liability cases, the obligation to defend all of those claims is not derived from contracts, as First American is asserting here, but instead it's derived as a matter of law.
Does that apply to permissive counterclaims as well as mandatory counterclaims?
That's correct, as long as they're inextricably intertwined, which I think is sort of the magic language that has been adopted. But most of, at least our appeals court cases that have dealt with this, have sort of summarily concluded, based on a footnote in that Aetna case from the SJC, that in for one, in for all. There has been very little discussion about the underlying policy implications that actually authorize or justify that conclusion.
Isn't there, I think it's the Aetna case in a footnote saying in for one, in for all, except if the parties by contract differ?
That's correct. That's the remaining portion. The question.
Oh, but you're saying this one doesn't. It really requires a specific. You would say, I take it, that if First American had, if this title insurance had said, we defend you for these things, and we specifically, it's agreed, we're not defending you for any uncovered claims if there's a covered claim, you would be bound by that, right?
Could you rephrase that again?
Yeah. If part of the insurance policy, there was an addendum or added to what is in it in terms of this is what we cover, what we defend for, and it said, and we, even if there are uncovered claims in an action that raises one of these, we will only defend you for these, if it said something like that.
Well, and I think the policy sort of indicates something to that effect. It says, as to only those causes of action which implicate the covered matters, which to me is very similar to what you're dealing with all of these general liability claims. I mean, they say we'll defend the entire suit, but only as to those.
How by contract do you?
Because this isn't a contract issue, and I think that was a quote from a treatise that was cited in the footnote. And I suspect there's a particular, there could be a particular circumstance where the parties actually negotiate an insurance contract.
Say that footnote is not expressing appropriate law. Is that right?
That's not. I agree that at least that portion of the footnote appears to be inconsistent with all of the law in other jurisdictions, which have basically, and including this jurisdiction. I mean, if you look at the appeals court cases, they're not looking at the terms of the general liability policy to come to their conclusion that you're in for one, in for all. Rather, they're implying this as a matter of law, because if they were to look at the underlying policy, it has very similar language. Not exactly the same language, but they, again, only want to be in for the covered claims. And if you look at the cases, and I think Judge Woodlock does a very good job of addressing this in his federal district court case, but if you look at the cases that deal with the issue, very few deal with the underlying policy justification. But in none of those cases does the court go back, even the appeals court, and look and say, here's the language that we're going to rely on, it's contract interpretation, because the language isn't there to support in for one, in for all. It's a duty that has consistently been applied as a matter of law based on various public policy issues. Those public policy issues appear to vary, but I did find, which is, I think, consistent with Massachusetts law, a Texas court case which said we looked for a bunch of these public policy issues, but it appears that our courts have just adopted it. We're generally relying on the general practicalities of having two attorneys involved and how that would ultimately impact the insured and what the insured bargained for. And I think those types of policy justifications apply equally here in this
If
context.
the language was clear, then how could you say the insured didn't bargain for it?
This is a standard form policy. There's no bargaining going on with these particular contracts any more than there would be for any insurance contract. I can imagine a particular context where the insured had enough bargaining power to actually enter into a more negotiated contract, but that's not the case with these standard form policies.
But the claims against GMAC are not claims that go to the specifically to whether there is a defect in title. It goes to what your conduct was after you learned of the defect in title. That is, you proceeded to collect on the loan, you proceeded to foreclose on the loan, and why is that not separate and apart from the issue of defect? And if we go there, then what else is the title insurer going to have to swallow?
That's not entirely factually accurate, Your Honor. In fact, we were collecting when we had an insurance policy which said that we had a valid first lien on this particular property. We were collecting the money in reliance on that title insurance policy, which we had an absolute right to do. That's the reason title insurance policies exist. They're to encourage the transfer of paper without the necessity of doing a title search. So there was no knowledge until sometime in December of 2009 where there was a claim, an unsubstantiated claim, that basically our mortgage was defective. There was then a series of exchange of letters, and then to the extent GMAC stopped its foreclosure sometime in March of 2010. Those 93A claims are in part predicated on the fact that GMAC didn't have what First American said it had, an insured first mortgage, a valid insurable first mortgage on the particular property. Certainly GMAC initially had the right to rely on that particular policy. At the time of foreclosure, it's customary for them to do a title search. At that point, they would have discovered the defect in their mortgage. And when they did discover it, whether it was through the 93A demand or through a subsequent title search, they put the title insurer on notice. And then they stopped foreclosure efforts. So I don't think it's entirely fair to say that this was entirely all GMAC's conduct.
We'll have to leave it there. Thank you,
Thank
sir.
you.
Good morning, Your Honors. Jason Manikis on behalf of First American Title Insurance Company. I think it's important to know what brought us here today, the certification questions from Judge Young in the U.S. District Court. The questions certified, the primary one is whether or not the language in 4A of the standard American Land Title Association policy, which is the policy at play here, requires the insurance company to provide a complete defense in a situation. I believe the question, Your Honor, is if there's an overlap of claims, whether there's a requirement for the carrier to defend those overlapped claims. Judge Young goes on to find, and again, I don't believe it's binding on this court, but he goes on to find that some of the claims, reformation, equitable subrogation with respect to the mortgage, are in fact title claims. In fact, First American had agreed to defend those claims without a reservation of right, had retained Attorney Circuit to file those in the land court, and when they became counterclaims through GMAC's private counsel in the U.S. District Court, they had him appear to defend those title claims. The other three claims, as Judge Gantz pointed out, are intentional interference with emotional distress, money hadn't received in 93A. Those all occur post-policy. They are all created by the lender. Those are all intentional conduct, and Judge Young found, we think properly, that those were non-covered claims. The question he then grappled with, because I think the law getting to that point is very clear in Massachusetts, what is and what is not covered. The question he then wanted certified to the Supreme Court, and again, he has simply adopted GMAC's phraseology of the certified questions, was, now that I know that some of the claims are covered title claims and some of them are non-covered claims, what do I do? And he then looked at 4A of the standard policy, which I believe is clear and unambiguous. It says repeatedly that the obligation to defend is a limited one, and it only applies to those stated causes of action that involve a covered claim. And again, it's repeated throughout Section 4A, those stated causes of action. Judge Young then found that because of that limited defense obligation, First American was only obligated to defend those covered claims. and not the non-covered claim. So now you have a situation which is a mixed action, as the court has called it throughout the nation in dealing with these types of things in a liability scenario. Judge Young then grappled with the comment in Aetna and other cases by this court that discussed the complete defense doctrine. And I think it's important to go back here. The complete defense doctrine in Aetna, while the court doesn't adopt it, I'm just going to assume from a liability standpoint that the court would adopt it. And I think that still has no bearing on the outcome of this case, because in Aetna, Judge Botsford, you pointed out the footnote. It says that the court may adopt that. The weight of mass authority seems to be going in that direction. It hasn't yet. And then it says that would be the rule of law if the court adopts it, barring contrary agreement barring contrary agreement by the parties. So that footnote, I believe, opens the door to exactly what Section 4A does. In fact, ALTA altered its standard policies back in 1990, 1992 with the addition to change it from we'll defend any litigation in which there's a claim to we'll defend those specific causes of action, those stated causes of action in which there's a claim.
But does the phrase by contract, does that refer to by the insurance policy itself, or does it essentially mean by agreement of the parties? They may say, the party being represented may say, well, I really want my own personal lawyer to represent me on these non-covered claims.
It's implied in the footnote. It just says barring contrary agreement with the insurer.
So there's no distinction made.
That there's no distinction made there. So when we're looking at a mixed case where there are covered and non-covered claims, there are 3 points to make. The first one is that under the freedom of contract principles, which I believe Aetna supports, and which is repeated throughout the history of the SJC, freedom of contract, that it's invaluable, it's in the public interest to have these agreements, parties are freely allowed to enter these agreements. You have Section 4A that was specifically altered back in 1990 and 1992 to provide a limited defense, and we think that language is clear and unambiguous. But when you actually look to the complete defense rule, first, there's no Massachusetts case on point that relates to title insurance. They're all liability cases. And when you actually look at it and analyze those cases in Massachusetts, as we've done in the brief, every one of them has a contractual underlying provision that says that the insurance company is required to, it has the right, first, and the duty to defend any action or suit, depending on which type of policy you're looking at in a liability scenario. So as the bus dissent comments, and as is found throughout cases in the nation, that is a negotiated provision. These liability forms are standard throughout.
The bus majority disagreed.
Well, the dissent in bus, the bus majority disagreed in the situation of a liability policy. The dissent, however, noted that these standard insurance forms, the ISO forms as they are, and in Massachusetts, auto policies, for instance, have to be approved by the Commissioner of Insurance. These are all standard forms. In bus, the dissent, I think importantly, Justice Joyce Kennard points out that the insurance industry negotiated for this right. And it doesn't just say they have a duty to defend any action or any suit. It says they have the right and duty to defend. And they said that this was a conscious decision by the insurance industry in a liability scenario because they wanted complete control of the entire lawsuit. They wanted a freer hand. They didn't want to have to parse it out. So,
well, that makes a lot of sense. But I would have thought, and do think that, don't the insurance companies, when they set the rates or when they charge their clients the premiums, built into that is this historical experience they have, at least in Massachusetts, that they're going to be defending the entire case.
That's correct in a liability scenario. Premiums aren't regulated in Massachusetts.
Liability scenario, isn't it?
It is not, I would submit, Your Honor. A title insurance policy is very different than a liability policy. It indemnifies only against an actual loss. It doesn't provide any benefit to a third party. It is drastically different. And I think what we'll see, what we would suggest, Your Honor, is when you're actually looking at this complete defense doctrine, assuming you think that the freedom of contract principle doesn't apply, and assuming you disagree with my comment that it's grounded in contract, given the specific language in those policies, which require defense of an entire suit or action, unlike the language in 4A, you're going to find that that these policies are very different. First and foremost, liability policies are all prospective. They cover a prospective risk. Unlike that, a title policy covers a snapshot in time existing on the date of the policy. You're also going to find that that the title policy continues in existence essentially forever, as long as the insured has an interest in that property and can't be canceled. Very different than a liability policy for a specific term. The premium structures are completely different. The liability policies are regulated in Massachusetts. In fact, our legislature has specifically carved out title insurance from the majority of statutory regulations in Chapter 175, thus acknowledging a distinction. So we have different premiums. We have different regulation with respect to these. And when we get down to the public policy considerations of should a complete defense apply, notwithstanding the contractual language and these other arguments, I think it would actually be a disservice to the public.
Because?
It would be a disservice because typically title claims, title companies under Section 4B have the right to institute or prosecute an action to resolve a title defect or to reduce exposure. Very different than a liability policy. Liability policies do not give the insurer that right. This brings us to the second certified question relating to 4B. In 4B, title companies often avail themselves of this because they require judicial determination to resolve title defects, reformation of mortgage, mutual mistake, equitable subrogation. Typically, these are brought in land court, although the Superior Court does have concurrent jurisdiction of these claims. The title companies need to have 4B in their policy because most of these issues, title defects, liens, encumbrances, can be resolved or greatly reduced through judicial determination. So 4B exists. And to answer your question, what's then the harm to the public? Well, the harm to the public now is you have these specialized attorneys dealing with title claims, typically in the land court, to open the door to things that are specifically excluded from the policy in a mixed action case, like a lender liability claim, TILA, RESPA, Fair Debt Collection Practice. These things all occur post-policy. They're all intentional conduct by the lender. You're now going to require them to defend these types of claims for which they do not have that much experience. You have these specialized title attorneys resolving title defects every day in the land court, and now you're going to subject them to lender liability claims. And understand, the title company does not participate in the underwriting of the loan. They play virtually no role at all in the underwriting of the loan. So they don't underwrite the loan, they don't use actuarial tables, they don't foresee future events of liability, and by opening the door, you're now not only requiring title attorneys to take on those claims with perhaps little expertise, you're also opening the door to one, recoupment claims, as BUS says. BUS is a recoupment claim where they're seeking reimbursement. They said, Carrie, you defended all these claims even though you shouldn't have, and we're going to imply at law that you can go ahead and get all your money back.
But as a practical matter, in that scenario, if somebody wants to file a permissive counterclaim, having nothing to do with, a built a quiet title or something like that, there may have been a fist fight 6 months before between the parties. You can oppose the counterclaim and essentially, what's your experience? What is the experience there? Don't Superior Court judges, if they would hear this kind of an argument, say, look, I'm going to deny the permissive counterclaim? They can file a separate suit.
I think that's a possibility. The Superior Court would deny that permissive counterclaim. There are other possibilities.
And then would you have to defend that under this policy?
No. With respect to Section 4B, the argument by GMAC is if First American avails itself of its right to prosecute an action to resolve a title defect, and there's a counterclaim, whether it be permissive, whether it be compulsory, whether it be brought in the Superior Court, and then there's a consolidation, which didn't happen here. In any scenario, GMAC's position is you invited this risk. You have to defend those claims. We strongly disagree with that. We didn't invite that risk. And more importantly, you would still analyze that claim under Section 4A. You would say under Section 4A, okay, there's a claim, however it arises. And that claim, is it either a covered claim or not a covered claim? If it's a covered claim, we're obligated to defend those counterclaims or third-party, whatever those claims may be. If it's not a covered claim, then under 4A, we're not. So GMAC wants to parse out, because it's a permissive claim or because it's compulsory, you should defend it. Under 4A, we might be obligated to defend it. If it relates to a title defect, lien, or encumbrance, or another matter covered by the policy, we absolutely would defend it. And if it's an intentional tort committed, an assault and battery by the lender post-policy, we would absolutely say that we are not. And it's not impractical to have multiple attorneys in a case. It happens every day in Massachusetts. Our office has a myriad of those.
Well, that's what I'm going to ask you about that. As a practical matter, if you've got your insured who's a defendant in the case, and so maybe the general rule that people aren't juries, and maybe this isn't even a jury case, I'm not sure. But, all right, there is a practical problem with having different claims that may, as a trial matter, overlap, and having one person stand up and then another person stand. I mean, it does seem as though that's not a great way to run a trial.
There are
Or to handle litigation in general, to have different people responsible for different little pieces of it who aren't connected.
With the first point, I agree to some extent. I think there are practical ways around it that happen every day in Massachusetts. With respect to the second point, I disagree. I think it's actually a disservice to have a title attorney specializing in title disputes handle TILA claims. I think that the insured, especially given what Bus said, that, hey, if you're going to defend these, even though you're not obligated to, then you can go get all your money back. I think it's a much better public policy for the insured lender to get counsel who is familiar with, who is well versed in these lender liability claims as an example, to defend them, as opposed to having a title attorney in the land court now defending these and then turning around and submitting his bill to the lender. I think with respect to the first question, Judge Botsford, with respect to is it practical? Well, typically a lot of these title claims are brought in the land court where you can't have counterclaims for monetary damages, thus avoiding this problem at trial. In a situation in the Superior Court, for example, where there are title claims and non-title claims, title companies often try to bifurcate these. In fact, GMAC continues to argue, well, but for the fact that we didn't have a mortgage and understanding that title insurance is not a guarantee of title or representation of title, but for your actions, we wouldn't have these issues. So fine, we'll bifurcate those claims for trial. We'll try the reformation or subrogation claims to figure out what it was. And then you can try your lender liability claims. It happens. You also have issues with respect to jury rights.
A counterclaim against a third-party claim against you, right? Maybe.
I didn't hear the question. I'm sorry.
On the facts of this case, it seems as though GMAC could bring a third-party claim against First American, if I understand the.
I think it's more common for them to bring a declaratory judgment claim. What happened specifically, Your Honor, in this case is the land court case was filed because the title company acknowledged there was a mistake in the mortgage. It would either be reformed because of the recording order, or they'd be entitled to subrogation because they had paid off a prior one and that Mrs. Moore shouldn't get a windfall. Mrs. Moore then, knowing that she couldn't bring monetary claims and having claims relating from the lender's conduct, sued in Superior Court. Those Superior Court claims were removed to the district court by GMAC's private counsel. GMAC's private counsel then brought counterclaims mimicking the land court claims. The attorney that First American already agreed. So they were all joined. There were two attorneys in that case, and typically they would work cooperatively to resolve it. The lender then would bring a claim at the end of that litigation, and under preferred mutual v. Gamarsh, that this case said, if the title company was wrong and it should have defended all those claims under Gamarsh, it's an exception to the American rule, and GMAC would then sue and recover all of its fees, all of its expenses, and as some courts have said, even potentially settlement payments, even if they were unreasonable. The lender would be punished for violating that. So I think that's how it would come up, Your Honor.
Can I just ask you one question?
Absolutely.
Having to do with the inverse situation. If two adjacent landowners get into a physical confrontation and there's a civil suit brought for assault and battery, or something that would qualify for defense under a general liability policy, and then the other party brings a counterclaim for adverse possession. Under the general liability policy, is there a duty to defend the adverse possession claim?
Under general liability policy, if this court were to adopt the complete defense rule, I believe that there would be. There are also in general liability policies provisions called other insurance provisions or escape clauses.
So if you have title
that may
insurance.
apply. So in fact, the Philadelphia indemnity case that's cited in the brief, there was actually a fight between a liability carrier and a title carrier, where the liability carrier said, well, there's other insurance, title insurance. You have to defend one claim, you should defend them all, and you should pay for all of my costs, and that's how that dispute arose. I think that the way that would be handled under the title policy is clearly intentional tort, the initial complaint is not a covered claim. The counterclaim dealing with whatever the property right is a claim. The title company would defend one, not the other, and that's how it would proceed under Section 4A. Those attorneys would work cooperatively, or they would bifurcate the title issue, finding that they're separate issues. There are many practical ways to do it, but it happens every day in Massachusetts, I would submit.
We'll have to leave it there. Thank you very much.
Thank you, Your Honor.